We're live.
Good evening, everyone, and welcome to the August 3rd, 2026 special council meeting beginning at 6:30 p.m. Tonight will be led in prayer by Councilwoman Montgomery, and if you would all please remain standing for the Pledge of Allegiance.
Let us pray. Father God, we come before you tonight and we thank you for a wonderful day that you've given us, beautiful skies, and lovely weather. Now, Lord, as we have met here together tonight, we have come that we might be led by your Holy Spirit, Lord. That's how I've been praying. So, Lord, be with us, guide us, and direct us. In Jesus' name, amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Mayor Perry,
Here.
Vice Mayor Croucher,
Here.
Ms. Montgomery,
Here.
Mr. Profit,
Here.
Mr. Nichols,
Here.
Ms. Butts,
Here.
Mr. Rourke.
Here.
All right, and on our schedule, number one is executive session, and it is to conference with an attorney for the public body concerning disputes involving the public body that are subject to pending or imminent court action. Do I have a motion to go into executive session for the reasons stated?
So moved.
Second.
Vice Mayor Croucher and Councilwoman Butts. Roll call, please.
Vice Mayor Croucher,
Yay.
Ms. Butts,
Yay.
Ms. Montgomery,
Yay.
Mr. Profit,
Yay.
Mr. Nichols,
Yay.
Mr. Rourke,
Yay.
Mayor Perry.
Yay. All right, we are going into executive session at 6:32 p.m., and we'll see you when we get back. Thank you. I would ask, please, that you provide some information. I believe you're prepared for that, correct?
Yes. I'm working on it.
So Mr. Zipfel put this together to say what the actual question that we're looking at right now is. So,
How do you get this out? Hold on 1 second. I'll be right, Mayor, if you can give me just a minute.
not a problem.
There we go. That's what I wanted, because it was putting my notes in it.
Yeah, we can do it.
Oh, it wasn't? I didn't even look up. All right. Good evening, council. Tonight, as you all very well know, you have two ordinances before you, ordinance 2020, or I'm sorry, 2026 and 2026. I'm just gonna close. All right. Both of these relate to a citizen petition delivered to the clerk of council on July 8, 2026. The petition asks to add a new section 9.06 to the city charter that would prohibit construction of a defined data center. The immediate issue for this council is whether the petition contains the number of valid signatures required to trigger submission of the proposed charter amendment to the voters of the city. Now, I will first explain that threshold issue and these two ordinances for you, council. I'll then stop and let you vote. Only after that vote will I discuss kind of the substance of the proposed charter amendment. So that's kind of the procedure for tonight. Now, the agenda, these two ordinances, they are mutually exclusive. Ordinance 2026, it applies a reading of section 9.03 of our charter and will determine that 10% of the electors, as listed in that provision of the charter, means 10% of the persons eligible to vote at the last municipal election. Under that reading, 820 signatures were required. Only 336 signatures were verified by the Board of Elections on this petition. Ordinance 21-2026 calculates that 10% threshold from the number of ballots actually cast at the last municipal election, which was 1,277 votes. Under that interpretation, the petition would only require 128 valid signatures, and therefore that ordinance 21-2026 would verify those signatures as sufficient and direct certification to the November 3rd ballot. Now, both ordinances, they can't stand. You can't pass them both because they're conflicting. If ordinance 20 passes, then 21 should be tabled indefinitely, or vice versa. Now, this is the full text of the proposed charter amendment. This was submitted to the city, to the clerk, on July 8th, as I mentioned. Basically at the top of it, now this is a provision, again, this is almost mirrored, if not exact mirrored, to a petition that was circulated throughout the state of Ohio to place this issue on the statewide ballot for a charter, or I'm sorry, an amendment to the Ohio Constitution. The requisite number of signatures required for that was not met. The Ohio Attorney General has not looked at the substance of this proposed charter amendment to determine whether it's constitutional or not. But just knowing this is where that proposed charter amendment arises from, it's also been circulated in a number of municipalities throughout the state. Now, in here, the definition of a data center includes one or more facilities used primarily or exclusively for digital information services and having aggregate monthly demand or peak load greater than 25 megawatts. And lastly, the section says it's self-executing. Now, I'm not going to discuss that constitutionality on the front end. Like I said, that's after your vote. We'll talk about the substance of it. That's because under Ohio law, only a court can decide whether this language is constitutional or not. Now, it would be preferable for these issues to be decided before a municipality spends the money to put this ballot, right, or I'm sorry, to put this measure on a ballot. But Ohio law does not permit that. They don't allow courts or board of elections or even a city council to make this or to go through this review process on the front end. It's only after the ballot is submitted to the electors and voted on and approved would a reviewing court ultimately determine constitutionality. This is a very rudimentary slide that shows the timeline here. The petition was filed with the clerk of council because under Article 18, Section 9 of the Ohio Constitution, it directs the petition to be submitted to the municipal legislative authority. So that's why the clerk received it. The clerk stamped it, secured the originals, provided those originals to the Board of Elections for signature examination. And the board reported that the petition contains 336 valid signatures. So the Board of Elections under Ohio law provides the definition of the signatures or the amount of valid signatures. Council is the body that must decide whether the petition is sufficient, and if it is, provide by ordinance for this submission to be put on the ballot in November. And so under that timeline, that's under, I think, 3501 of the revised code, the deadline to put it on a ballot, to put this to the November ballot is August 5th, which necessitates this special meeting. It's actually at 4 p.m. on August 5th. This is section 9.03 of the city's charter. And the first sentence says that the charter, any charter section may be amended as provided in Article 18, Section 9 of the Ohio Constitution. It's submitted to the electors of the municipality. These amendments to the charter may be initiated by either a 2/3 vote of members of the council or by a petition to the council by 10% of the electors of the municipality. And the dispute or the question, I guess, boils down to that last sentence. What is the electors of the municipality? If the electors means those registered to vote at the last municipal election, the threshold signature requirement is 820. If electors means those who actually voted in the last election, that threshold is 128. Now, as our charter references Article 18, Section 9, we can go to that provision as well. Here, I won't read the entire thing to you, but if you watch my cursor in here, these amendments to a charter, as noted in the Ohio Constitution, it can be submitted to the electors for a vote by either a 2/3 vote of its council or upon petition signed by 10% of the electors of the municipality. The remainder of Section 9 incorporates some timing requirements, and Section 8, which is actually, Section 8 is the provision that applies when a city or a municipality wants to become or establish its own charter, or as we refer to it as, the city's constitution. And here we see this term being used in multiple times. Like we said here, the threshold is 10% of the electors of the municipality on the petition. The copies of the proposed amendments may be mailed to the electors. And if any such amendment is approved by a majority of the electors voting on it, then it shall become part of the charter of the municipality. And this language is important, and it's been subject to some case law from the Ohio Supreme Court. And let me give you a little backdrop on this. And any election law case in the state of Ohio has original jurisdiction with the Ohio Supreme Court, meaning you can go there and file it immediately. And with an elections law case, they are expedited as a matter of rule by the Ohio Supreme Court, meaning the decision is rendered in a matter of weeks. The matter is submitted on its briefs, so there's not a trial per se, and the decision is ultimately rendered before the November election, so that the Supreme Court expedites this so to make a decision before the upcoming election on any type of challenged election matter. And frankly, there are plenty of them filed with the Ohio Supreme Court annually. Another provision in this kind of procedure is that Ohio Supreme Court, while it does expedite these cases, it will not address or is very reluctant to address any matters not squarely addressed in the briefs of the parties. And so what this means is, this is a very narrow issue on what does this definition of electors mean. It does not come up very frequently. And in fact, while this constitutional amendment was initially adopted in 1912, the first real case we had from the Ohio Supreme Court on this topic was in 1995. The Ohio Supreme Court made the original decision that Article 18, Section 9, actually where it references electors, it means 10% of the eligible voters within that municipality. 8 months later, after the timing of that proposed charter amendment was over effectively, meaning it was not placed on the November ballot as requested by the petitioners, the Supreme Court reconsidered itself and in a 4-3 vote flip-flopped. And what's important about that is there's 3 justices that wrote the majority opinion. It was not 4 of the 7, it was only 3 of the 7. The 4th, which was Justice Pfeiffer, he concurred separately, recognized the implicit contradictions within the Ohio Constitution, in particular Article 18, on this definition, but just said, I think we'll just harmonize it by ruling this way. It's a very short concurrence opinion in there. That's really the governing law we have. And in that provision, or I'm sorry, in this Huebner case, it was not squarely addressed on home rule authority to make this determination. It was merely, let's look at Article 18, Section 9, and see what this word electors means. Let's see here. This history explains why this issue remains controversial. It was controversial at the time of the decision being passed, and frankly, this is an issue percolating throughout the state right now with a very similar amendment in cities statewide. There's 6 cities, I think, dealing with this proposed charter amendment at this time, and also the question about the number of electors required to sign that petition has become an issue in almost all 6 of those. So this is, as I said, the definition of electors is based on the last general election. So I've provided the data from the November 2025 election for the city of Trenton. At that time, actually July 1 of 2025, the U.S. Census Bureau estimated the city's population at 14,241. The Butler County Board of Elections has confirmed that at that time of the November 2025 election, there were 8,197 eligible electors living in the city of Trenton. However, there were only 1,277 ballots cast at that election. And that is about 15% of the registered voters actually voted in that election. This likely reflects or is a result of the fact that there were no statewide or national races on the ballot. There were a few local items on the ballot in November 2025. If the votes cast, if electors is defined as the votes cast at the last election, then only 128 signatures is required on the petition. If electors means those eligible to vote, that number requires, or I'm sorry, the 10% of the electors rises to 820 signatures.
Can I ask a question
Yeah.
at this time? If we are to, if we're to define electors as people that voted in that election, if we are to accept that, and the 100 and I'm trying to see how many 127 signatures is the valid amount that we have to.
128.
128 is the valid amount. Do we know how many of the signatures actually voted in that election?
Yes, we do. We've cross-referenced the data. There was, of the 336 signatures that were verified, I think 113 actually voted in the November 2025 election.
Okay. Go ahead, carry on.
Thank you. So the result of, if you take in the definition of electors means voters, the amount of signatures required to put a charter amendment on the ballot is 1.56% of the registered electors. That's a practical interpretation. 128 signatures out of 8,197 is 1.56%. Now, the city, like I said, has adopted its own charter amendment provision in its charter, where it does incorporate Article 18, Section 9. It also includes its own provision in there. While it might mirror Article 18, Section 9, it is separate in there, where the city has stated that an amendment may be made by either 2/3 vote of the council members, meaning if you had a petition that council wanted a charter amendment, it doesn't have to have a signature on it if there's 2/3 vote of council, or 10% of the electors of the municipality. Now, that term is not defined in our charter. But based on section 1.03 of our charter, where Ohio law will fill in the gaps where our charter is silent. And these are the definitions under ORC 350101, which is the Ohio election law chapter in our Ohio Revised Code. An elector under that chapter of the Revised Code is defined as a person legally entitled to vote. A voter is defined as an elector who actually votes. Those are in, like I said, 350101 of our Revised Code. So this distinction comes down to what does elector, how is that defined in section 9.03 of our charter? We have some gap fillers here with the Ohio Revised Code. Now, when we look at it, these are the slides that kind of show a comparison to the other provisions in our charter relative to petitions that can be placed on the ballot for a vote. You have the charter amendment, which we've discussed. I put at the top there. This is all based on the November 2025 election. The minimum is either 128 signatures or 828 signatures, depending on how you define electors under section 9.03 of the city's charter. An ordinary initiative petition, this is, so, just for background, there can be a petition, or what an initiative petition would be is, hey, we want to have an election to see if we want to pass this law. This law would be an ordinance on our books, but it would not be a part of our charter. And it would be subject to, modifications, much like every other ordinance in our code of ordinances is. And under ORC, well, actually, section 8.03 of our charter says, hey, we're going to follow the Ohio Revised Code for these types of elections. That drops down to ORC 731, 28, and 29, where it says an initiative petition must contain 10% of all electors who voted for governor at the most recent governor election. I don't have the exact data on who voted, the number of votes cast for governor at the 2022 election. What I do have is the number of votes that Governor DeWine, right, the winning candidate, received from the city of Trenton at the November 2022 election. And there, Governor DeWine received 2,841 votes from the city of Trenton. Governor DeWine received 62.4% of the vote statewide. So this is my assumption here, but at the very minimum, if everyone in the city of Trenton who voted at the November 2022 election for governor voted for Governor DeWine, meaning he got 100% of the votes out of the city of Trenton, the minimum number of signatures to place an ordinance on the ballot to be passed would be 285 signatures. If Governor DeWine received 62.4% of the vote in the city of Trenton, much like he did statewide, the minimum number of signatures for an initiative petition would be 453 signatures. It's a rough estimate. Like I said before, I don't know the exact number of ballots cast for governor in the November 2022 election within the city. I can obtain that information, but I only provide this for context. The referendum petition, and this is a petition in which the signatures would be received within 30 days of passing an ordinance by council, and the petitioners would like to put that passage of that ordinance to vote under, I think that's ORC 731-29 as opposed to 28 for initiatives. It requires 35% of all the electors who voted at the last governor election. And that's how the language says, the electors who voted at the last election. That's how ORC 731 puts these terms. Based on the same number of Mike DeWines and extrapolating that out, the minimum signatures for a referendum petition is 995 signatures. If Governor DeWine received 62.4% of the vote in the city of Trenton back in 2022, The minimum number of signatures for a referendum petition is 1,594, which I think is like 14 or 15 times what that 128 number would be for a charter amendment. So one second. This comes back to the ordinances before you tonight. Like I mentioned, these are mutually exclusive ordinances. Under Ordinance 20-2026, it is drafted as the City Council interpreting its charter, Section 9.03 in particular, to including the last sentence where it defines 10% of the electors required for a charter amendment as being those actually eligible to vote at the last municipal election, and that would comport with ORC 3501.01. And that ordinance would have the practical effect of saying 820 signatures were required for the charter amendment petition, only 336 were verified. Thus, the charter amendment petition does not meet the requisite number of signatures. Under Ordinance 21-2026, the definition, the city's council's interpretation of electors under Section 9.03 of its charter would be based on the actual votes cast at the last election. As I mentioned before, there were 1,277 votes at the November 2025 election. Thus, only 128 were required under that interpretation. The 336 submitted, verified signatures would otherwise meet that threshold, and council would pass the ordinance that would certify that the petition be submitted to the Board of Elections by 4 p.m. on August 5th so that it can be placed on the ballot. Those are the two ordinances before you. If you have any questions, happy to discuss them. And like I said, after council deliberates and debates and makes their vote, I would welcome the opportunity to kind of discuss kind of the substance of it thereafter, just a little bit at that point.
What were the total number of signatures turned in?
400 is in the 400s. I think 464.
For the most current, the petition that
Yes.
was around, I believe.
I'll double check that one.
Yeah, double check that real quick.
I'm going to unplug this so I can go through my computer if you don't mind.
Council, are there any other questions? All right. Give it a couple seconds here.
Yeah, 1 second.
$464 signatures.
How many?
464 signatures.
4, 6. Okay. All right. At this time, we'll move on to legislation, and I'll entertain a motion that we read items 1 and 2 under legislation by title only.
So moved. Second.
Vice Mayor Croucher and Councilman Nichols. Roll call, please.
Vice Mayor Croucher,
Yay.
Mr. Nichols,
Yay.
Mayor Perry,
Yay.
Ms. Montgomery,
Yay.
Mr. Prophet,
Yay.
Ms. Butts,
Yay.
Mr. Work.
Yay.
Item 1, an ordinance determining that the petition for submission of a proposed charter amendment to the charter of the City of Trenton, Ohio, does not contain the number of valid signatures required by Section 9.03 of the charter in declaring an emergency. Item 2, an ordinance providing for submission of the proposed amendment adding Article 9, Section 9.06 to the electors at a special election to be held November 3rd, 2026, directing certification to the Butler County Board of Elections and declaring an emergency. And may I just comment real quickly? Technically, it is a special election, though the Board of Elections will consider it a general election because under the Ohio Constitution and I believe our charter, the general elections for municipalities are only on odd number years. So, but they treat them the same for each. It's just technically a special election.
Okay. Thank you. Before we vote any further, Stas, please follow the general way that we have been voting, with me voting last, please.
And can you also note that both of these are ordinances, so they would require a suspension of the required 2 readings.
Yes.
Either way, council decides. I just wanted to be certain that council understands that.
All right. Thank you. Well, knowing that, I will entertain a motion that we waive the 2 readings and vote on number 1 on your legislation tonight.
Mr. Mayor, I would like to make a motion that we table item number 1 indefinitely.
I second
All right. Motion was made that we table number 1 indefinitely. Roll call, please.
Ms. Butts?
Yay.
Mr. Rourke?
Yay.
Mr. Nichols?
Nay.
Vice Mayor Croucher?
Nay.
Ms. Montgomery?
Nay.
Mr. Profit?
Yay.
Mayor Perry?
Nay. We will entertain a motion that we suspend the readings and vote on number 1 tonight.
So moved. Second.
Vice Mayor Croucher and Councilman Nichols. Roll call, please.
Vice Mayor Croucher?
Yay.
Mr. Nichols?
Yay.
Ms. Montgomery?
Yay.
Mr. Profit?
Yay.
Ms. Butts?
Yay.
Mr. Rourke?
Yay.
Mayor Perry?
Yay. All right. I'll entertain a motion that we approve number 1.
So moved.
Second.
It is Vice Mayor Croucher and Councilwoman Butts. Roll call, please.
Vice Mayor Croucher?
Yay.
Ms. Butts?
Nay.
Ms. Montgomery?
Yay.
Mr. Profit?
Nay.
Mr. Nichols?
Yay.
Mr. Rourke?
Nay.
Mayor Perry?
Yay. All right. I will entertain a motion that we table number 2 indefinitely.
So moved. Second.
Vice Mayor Croucher and Councilman Nichols. Roll call, please.
Vice Mayor Croucher?
Yay.
Mr. Nichols?
Yay.
Ms. Montgomery?
Yay.
Mr. Profit?
Nay.
Ms. Butts?
Nay.
Mr. Rourke?
Nay.
Mayor Perry?
Yay. All right. We'll move on to reports. We'll start off with Mr. Beresford.
Thank you, Mayor. I have no reports.
Oh, I'm sorry. Do we have a further presentation?
Yes, we can go through.
Yes. We can do it after reports. All right. Mr. Ziffel.
Mayor, I have no reports other than
Thank you very much. Mr. Nichols.
Thank you, Mayor Perry. I have no reports this evening.
Thank you very much. We'll move on to audience of council.
No report.
Mr. Profit.
No reports.
Councilwoman Butts.
No report.
Councilwoman Montgomery.
No report.
Councilman Nichols.
It's been a long evening. I'll save my comments until Thursday.
Vice Mayor Croucher.
I concur with Councilman Nichols. I have no reports.
And I agree as well. And we will go to Mr. Ziffel.
Thank you, Mayor. And I know we've had some conversations or questions, at least, about what this amendment means. And like I said before, I didn't want to discuss a lot. I didn't want to discuss this with council before you had the vote because substance doesn't matter, right? Council's decision was how do you define electors under Section 9.03 of your charter. In fact, council should not consider the substance of a charter amendment before this type of decision. So I'm going to go through it now because council's had some questions, and I've actually fielded some questions from members of the community, and I did go through the language at the beginning. What are the key terms here, at least in my personal opinion, of how I evaluate this? Just to give everybody some kind of insight on the way I'm looking at this. This is provision that has 4 key points in it. And like I said, it does mirror the one submitted to the state of Ohio. According to the Ohio Attorney General's procedures for a statewide amendment to the Ohio Constitution, the Ohio Attorney General does not evaluate constitutionality on the front end. The Ohio Attorney General actually does have the authority to evaluate it upon receipt of a sufficient number of petitions. The Ohio Attorney General did not receive a sufficient number of petitions to place this on the Ohio Constitution, or to place it on the ballot for an amendment to the Ohio Constitution. So he's not made this determination. But the 4 key pieces I see in here is it's a citywide ban regardless of the zoning classification, includes a prohibition on any construction or modifications of a data center, regulates based on the amount of energy used, and is self-executing, meaning it does not require council, or it includes all enforcement provisions in its own words, as opposed to requiring council to adopt legislation that would otherwise enforce this charter amendment. So, like I said before, this constitutionality will only be decided by a reviewing court if it's ever voted on at an election. And we've talked about it. There likely could be a challenge to this through the Ohio Supreme Court's expedited case, and if there's a decision the other way, it will be placed on the November ballot. So, if that's to occur, then that's fine. This is my evaluation of the current standing Ohio law on these particular topics. Let's see here. The absence of grandfather provision in here is particularly important because it creates the argument that the amendment is intended to reach projects that the city has already approved. That includes also the language of construction and modifications to any data center, which is prohibited under this proposed charter amendment. Now, the closest case I've been able to find is actually from the Southern District of Ohio, and it was the Center for Powell Crossing versus the City of Powell. And this is a 2016 case where there was a citywide petition for a charter amendment. And the charter amendment was to require all zoning measures that were previously enacted or otherwise moving forward to be placed on a ballot for the entire city to decide on any zoning change. Every time there was a zoning change, the entire city would have to vote on it. The signatures on the petition exceeded the threshold of electors as defined, however you want to define it. And the measure went to the ballot. It was approved. Immediately thereafter, the Center for Powell Crossing filed a 1983 takings claim, meaning they had a substantive due process in right in using their property in a way that the Center for Powell Crossing had already generally agreed upon, even though they had not signed the final agreement. And the developer said this is an unconstitutional takings of my property interest. So, like I said, the main issue there, the charter amendment was going to prevent Powell Crossing from developing its property in a manner that had already been tentatively approved by the City of Powell. The interesting thing here is that the Southern District of Ohio looked at the practical effect of the charter amendment, even though it was a charter amendment. It was not a referendum petition. In fact, no referendum petition was ever filed because it was an administrative decision on approving the underlying zoning. It was not subject to a conditional use. It was an administrative decision so that if there was a challenge to it, they could not, because referendum petitions are not valid for administrative functions of a city government. You cannot put to referendum an administrative act. You can only put a legislative act to referendum. So, let's see here. The Southern District of Ohio noted that as a referendum would, the proposed charter amendment presented voters with the opportunity to either affirm or revoke city council's actions. So city council in that case approved the project, voters filed this charter amendment, and immediately upon the election, the project stopped. The developer filed a lawsuit against the city of Powell. And so according to Southern District of Ohio, if the real effect is to approve or revoke a previously approved project, the court will treat the measure like a referendum, not like a charter amendment. The Southern District of Ohio, in this opinion, stated that the petitioners and the electors who voted on it may not exercise the power of referendum by means of a charter amendment so as to nullify an administrative action. And because of that, the Southern District of Ohio invalidated the charter amendment in its entirety. So even though it was voted by and approved by the electors at the election, because it was formed as a referendum and not, even though it was titled charter amendment, it had the practical effect of a referendum, Southern District of Ohio said that that does not fly, and thus the entire charter amendment, not just the charter amendment applied to the center of Powell Crossing, the entire charter amendment was unconstitutional in its entirety, because there was, in that case, there were other developments around the city that would otherwise be subject to this new law, and that had not even begun their construction. Southern District of Ohio focused on the intent of that charter amendment, determined that it was a referendum petition disguised as a charter amendment, and validated the charter amendment in its entirety. So that's the case that's biggest on point here with respect to the procedure we have in the city. But there are other issues. These are unknowns to it. One other issue that frequently comes up in terms of determining constitutionality of a charter amendment is vagueness. The provision I see concerns with is the 25 megawatt provision. Now, I am not an electrical engineer by any stretch, but the ambiguity comes to me not only in what is a megawatt, but really more how do you apply it from a legal standpoint. That's what I'm focusing on. Does peak load mean actual metered load, design capacity, contracted utility service, transformer capacity, or a one-time peak? Is it monthly demand on average, a billing demand, a maximum? And the questions continue to go on from the vagueness of this provision. And as we know, if under Ohio law, if the charter amendment does not give persons, sufficient clarity on how to avoid prosecution or liability under that provision, it will be determined unconstitutional for vagueness. The other issue, this came up in another case, a Goldberg case out of the state of Ohio, as well as Powell Crossing, was one use in a zoning industry that is singled out with no clear view of the rational basis when compared to the other permitted uses in that zoning district. The issue in this case is, and this came out of the Goldberg and Powell Crossing cases, is that if you're targeted amongst other similar uses in the same zoning classification, there is a due process or equal protections argument that you are being unfairly, and remember, as we know, corporations are people under Ohio law, being the corporation that is constructing whatever development, are being unfairly singled out with no rational basis. There is that argument out there. Again, there's plenty of facts that are not known yet. I'm just pointing out the potential issue.
I do believe, if I'm not wrong, that corporations are people under federal law as well, correct?
Yes.
After the Citizens United decision?
100%.
Okay.
Now, the other issue I saw with it is the utility regulation. This is an issue that comes up under, it was the Canton v. State case. Let me see if I got that title. In the state of Ohio, and it was a 2002 case where that was analyzing utility regulations in a charter provision. And there the court looked at whether the Ohio Revised Code and the Ohio legislature effectively preempted the space by drafting and passing an entire section of the Ohio Revised Code to encompass the space. And if that's the situation, a charter municipality cannot override a general law of the state. So if the Ohio Revised Code effectively assumes the space with their own legislature, the chartered municipality, if it's a general law of the state, cannot conflict with that. Here, the Canton v. State case found in 2002 that Public Utilities Commission of Ohio has effectively, and the Ohio legislature has effectively assumed the space of regulation of energy in the disbursement sale of energy, and that the provisions with that municipality, I can't remember which one was involved in that, they are invalid because they cannot conflict with the state laws. So that's another serious concern with this, is the regulation of not only how that's regulated, but also the fact that it's being regulated in of itself. This is a as applied preemption issue that's been addressed in 2002 by the state of Ohio. So if a reviewing court ever decided in line with the state v. Canton case, the ultimate result would be that the charter amendment is invalid. Again, this is just providing some context for evaluating this as we move forward. The other provision I wanted to talk about, and like I mentioned before, I can find 6 municipalities dealing with this probably tonight in their own meetings with very similar proposed charter amendment language. And in those cases, the majority of them are evaluating what does it mean to be an elector and how is it defined under their own respective charters. The issue, or the case I want to bring up here, is a similar case, but it's one I think was addressed in the audience public at one of our recent meetings. And this is a case, it's Thor Equities versus City of Urbana. This is showing where I think the City of Urbana had a permitted use for data centers, provided this assurance to Thor Equities, which is the corporation proposing to build a data center in the City of Urbana. The parties didn't even reach an ultimate agreement on it, had been discussing it. Thor Equities submitted their site plan, right, for their permit. It was a permitted use at the time. City of Urbana did not respond, but instead passed a moratorium prohibiting data centers. Thor Equities initiated this lawsuit, and what's important about this lawsuit is it reflects the other provision of these takings claims is, the intent behind the takings, right? You had a vested interest, you had a right to develop your property in this way. The reason why that's taken away is of no bearing or consequence to this analysis, whether it's the City of Urbana Council's decision to change their policy, or if it was a charter amendment. Either way, there was a vested interest that was taken, and this was a data center of similar size to the one currently being constructed by Prologis. The actual damages of dollars being spent, and this was even before a shovel was in the ground in the City of Urbana, was $19.6 million. This is alleged in the complaint, with a lost $118 million profit to Thor Equities, which Thor Equities is entitled to receive under state and federal law, and any takings claim that they are entitled to their lost profits. So just wanted to clarify, I know we talked about or had heard about other cases popping up on this exact issue. This is the only case I could currently locate on this exact topic. And in there, it was slightly different, though, because the city of Urbana did change their own permitted use to a moratorium. And that's all I have for it. So we've got, some issues with it on terms of constitutionality, and then, the subsequent litigation, if there ever was to occur. It doesn't matter the reason why there was a takings. Invariably, there is a takings. The damages are what they are, and that was a comparable one that is currently pending. I don't know if it's in the Ohio Supreme Court. I'll have to double check that. Might be in Southern District of Ohio. But that's all I have. Any questions at this point? Thank you for your time.
I do have a question. I know we got into PUCO and everything else in that discussion. Prologis has their electric already reserved, bought, and paid for, correct?
That's correct.
Does AWS have the same?
I believe so. I'm not entirely certain. When we say bought and paid for it, but yeah, it's been secured.
It has been secured.
Allocated, and of course, as we've discussed, that has no bearing on the residential grid. It's an entire separate entity, and that it has been reserved for Amazon. I don't know if they've finalized whatever agreements they need. We're not parties to those agreements. We have no bearing in them.
Okay. All right. Council, anything? With that, I will entertain a motion that we adjourn tonight's proceedings.
So moved.
Councilwoman Butts and Vice Mayor Croucher. Roll call, please.
Ms. Butts?
Yay.
Vice Mayor Croucher?
Yay.
Ms. Montgomery?
Yay.
Mr. Prophet?
Yay.
Mr. Nichols?
Yay.
Mr. Rourke?
Yay.
Mayor Perry?
Yay. We are adjourned at 9:00 p.m. Thank you, everyone.
Never had a PowerPoint like that where it shows my notes. Really?